Welcome. This is the Domain Name Law Show. We're here every Tuesday. That's noon Pacific, 1 p.m. Eastern. No, 3 p.m. Eastern. Noon Pacific, 3 p.m. Eastern. I wanted to say thank you for joining us. This is not, I was going to say a dirty business. This is a dirty business a little bit. Domain Name Law. There's three hosts to the show. My name is Todd Ryan. My co-hosts are David Michaels and Jeffrey Newman. I'd like to get the show rolling by saying hello to my co-hosts. Hi, David. How's everything going with you today? Yeah, today's a good day. Sound like Ice Cube. All right. I know Jeff's in Manchester. My sister's in Liverpool today. She's from Indiana, but she went there to see the home of the Beatles and some stuff. She's an enormous Beatles fan. She just happened to go there last week, and I thought, yeah, pretty interesting. She's did a lot of the normal sites, and then she's went to Liverpool today. She was on Abbey Road yesterday. Yeah, just like everybody does, walks across the street, takes pictures. There's cars like, fuck, man, can we go or no? But anyway, so Jeff is over in Manchester at the ICANN Contracted Parties Summit. That is for the registries and registrars. Jeff was on a panel today, and I missed the panel because you have to sign up for these ICANN events 2 weeks in advance, or you don't get the Zoom link because they do allow you to attend virtually. And I thought I was like always, I didn't recall before having deadlines that I had to sign up by because I thought I could just sign up at the last minute. Anyway, so Jeff was on a UDRP panel today. There's a lot of big panels there. He was actually on a panel by himself. I'll get a update from him next week and see what he talked about. And I saw a lot of familiar faces there and some photos and stuff. But okay, so that's what's going on. ICANN Contracted Party Summit today. As soon as I finish this, I'm going to be going to Burbank and flying over to Dominion Conference for the next couple days. That's in Las Vegas. It's a conference D3 and DOMA put on. It's pretty cool. I mean, I look forward to seeing a lot of guys, but Monty's going to be there, and Richard Lau, and of course Amar, Fred, who does the show, puts on the show, him and his whole team. Cool to see them, but I really want to see John Moriello and Larry Fisher. That was the buyer broker and the seller broker for that deal, AI.com, and I know they're going to be talking about that. I think Thursday. I'm moderating some panel that's me and Aaron Maistat, who owns Symbolics, the very first domain name, and then another gentleman who runs, I believe, Nicknames, a registrar. We're talking about just, I don't know, future of domains. But we're really talking about some things that the registrars are doing now, new registrars, and just, a lot of talk around tokenization and stuff because that's what DOMA does, tokenize names. But anyway, so that's as ICANN Contracted Party Summit for the next couple days. We've got the Dominion Conference. And, hey, David, you haven't done any traveling for 5 years, 6 years, it seems like to me. But have you done any traveling lately? I mean, in any upcoming travel on your agenda? I like that you rolled into Buffalo. Um, yeah, how far is the the border from your place? Is it like an hour and a half? Yeah, well, I'm going to thank everybody for joining us always here. Domain name law. So we cover domain legal news, mostly review recent UDRP decisions, which are domain disputes, and yeah, a lot of disputes coming across to our desk over at Jeff's law firm, JJN Solutions, and it's really interesting. There's a couple cases today. One I really like that Kirkland Golf decision. Dave, we're going to talk about it. Before we get to that, though, I wanted to say there was some talk on the internet too. I forget what it was. Somebody was posting, and I just thought it was interesting, and I thought of it about how domain investors basically you still get there's going to be some people who never consider this legitimate business. Now, some of us have been doing it for so long that we know, people don't like, it's like a used car dealer, I guess. They don't like certain types of businesses. And I think used car dealers finally been around so long that people realize, of course, it's just used cars. Or people, buying domain names. There's going to be, even if this industry lasts 50 years, I would say the domains, and maybe they will, there's going to be some folks who always believe that you're just a cyber squatter, meaning we know you guys want to act like it's property and you've bought up a bunch of stuff and now you're waiting for somebody who wants to develop on it. But a lot of people think, it's just, you're just stepping in the way of businesses. Why wouldn't you just leave these things unregistered? Of course, we know you want to get in between the name and a business. So then the business is like, damn, they, got the spot that we'd like to have. So now we're going to have to pay them for the spot. It's like waiting in line and you just take up a bunch of, or, if you want to think it in a negative way, it's like somebody just saving a bunch of seats because you can, it's legal to do, but yet you can't sit in all those seats. So you got a bunch of them so you can resell them. It's just like reselling tickets. People think ticket scalpers, if you're somebody who buys and resells tickets, you don't call yourself a scalper. But the people that have to pay that premium because you decided saved a bunch of seats along the hillside and nobody else can watch the concert unless they pay you. So, I mean, I totally get it. I'm a domain investor and I'm on the domain investor's side. But David, do you think, is that still an okay argument? I know no one likes to talk about it. I mean, that's not true. People are posting about it, I mentioned. But is it okay for people to think, domain investors, they're just fucking, they are squatters? Have I ever heard what? Oh.
There's a market value. But to these guys, well, every name is $1 million name. They might as well be Rick Schwartz, but sometimes it's even worse. So the close theorem says that if you put the price that's reasonable or the highest value that's targeted the highest value user of it, then you're saving the name for that user. Otherwise, it'll be wasted on somebody who's a lesser value user. Does that make sense? So the guy who's trying to use a high quality oneword.com domain name for his school project is going to be a waste because he's going to tie it up on the school project and the next big business will not be able to buy it. They just won't even be able to find the guy, much less have it listed anywhere. So that's the counter argument to the squatting argument. The squatting argument, I think, should have died in 2005 because the ACPA and the UDRP came out around 1999, and anybody who was squatting on names back then, well, they should have filed a UDRP complaint then. Not now. Why are they waiting 25, 26, 27 years? It's too late now. Those names are old. And if you didn't have a claim to them then you definitely don't have a claim to them now.
Well,
What do you think about that argument?
no, and I understand the argument because it's sort of like saying, hey, with registries or registrars, if they made it a requirement that you have to develop out a name before you can acquire it, and then like David, like you said, people are going to acquire them and develop them in these little bullshit websites, because what is going to be the criteria? You're going to say, no, it's going to have to generate this much revenue. Well, some people just have a little, a blog or a small business that may not even have any sales in a certain month. And is that not considered a business? Because let me tell you, most businesses, if you break even, that's better than losing, right? And so most businesses don't even make money. But I guess the point is to have requirements. You're right. Then it's going to be like, okay, so now people have registered these things, put on these micro businesses in most cases, and now it's not even available to the end person. At least a domain investor picked them up, thought about them, picked them up, and have made them available. But I think, I'm just playing devil's advocate because I know a lot of domain investors in the room, and no one likes to feel like, well, one, if I, my position is like, good. If you think that about domain investing, then you're not going to like that portion of my life because I'm a domain investor. And if you think that's squatting, then you're not going to like that part. I think I do some other things you may like. The point is, I do consider it, if I was playing devil's advocate, that it is like somebody going and saying, hey, I got all the time in the world. I'm saving all these seats in the first 10 rows. So anybody wants to sit in the first 10 rows, you got to deal with me. And it's like, all right, well, then you wait until the band goes to the next city, and then maybe you try to save the first 10 rows. I guess, it's just I can totally understand how uh, other people in businesses think, geez, so you guys just get it, sit there, and then wait until someone wants it. And then in a lot of cases, that's not reasonable. You guys don't want, 10 times your money. Um, Sometimes you want 100 times your money. It just doesn't seem anyway. Okay, getting to our first piece of news. I just think, domain investors, they got to take it. You want to come in there, and some truly are, buy 1,000, 2,000, 5,000 names, 10,000 names. You can make a case for this person is, purchasing all these. Of course, it's a risk, but no one's cared about the risk. They're like, listen, we hope you do lose money. You're a squatter. That's how they feel on the other side. And it's still prevalent out there. I mean, there's still people in business. You post things online, and there's still people who that's all they know about domain investing is you're you're grimy. Okay, Verisign's raising the rates. So you saw that, David, right here in November. It's going up to 10.90, I guess, or something. It's going to eventually get to $13 here in the next 3 years. Does that affect your domain investing at all? It's extra $3 or $4 per
Oh
name.
yeah, absolutely. A lot of names are not worth holding for that long. You don't want to be holding on, 1,000 small geo names that are worth $500 at best. Um, it's just not a profitable business unless you have high sell-through rate and you're outbounding all day. So yeah, you need to only hold on to the um, best quality names and have a small portfolio. I think that's the way forward. With all these other price increases of the .org going up and .net going up all the time, it's just a never-ending squeeze. The registrars are the squatters.
Yeah, I agree with that. I know some people are growing portfolios, not, shrinking their portfolios. Went down to I'm at 1,000 names, probably just under, I'd have to say, because I have some AI names, probably half dozen of those, and I have a couple other like medical.chat. I had a few, just like ones or twos of, maybe I got like 4.bot, gambling.bot, land.bot. But I do like to have a few other, just a few other extensions, but I'd say, yeah, I'm down to about 900 names. Um, yeah, and I agree with you, David, that it's better to have smaller portfolio, higher quality, but that's not how, that's not the strategy for a lot of domain investors because you want the activity, and it's sometimes it's tough to pick. I know you've had sales like me, David, where you're thinking, geez, I have a bunch of great names, really at similar price, but yet you pick this random name, and I'm getting more activity on my 3 character that don't even, you know, you think there's a 4 letter that's random, a 3 character, boy, those are really C4O.com, not C40, C4, like, and in negotiations on a couple three character right now, and really I'd almost let him go for anything. So I hope I can close those. Uh, Before we get to our UDRPs, we're going to get in and out of here before 1 p.m. my time, before 4 p.m. Got to fly out today. Um, there was, I think there's a lot of opportunity. We're talking about renewal prices. I think there's, when I say a lot of opportunity, I just mean I know there's some opportunity in this next round of GTLDs. Now, I'm dealing mostly with companies that are getting their dot brand, and I think the world's a lot different than it was in 2012. But so I know there's a lot of companies and how they're going to use their dot brand internally and a little bit with their clients that makes a lot of sense, and they're going to incorporate in how they do business. So it's very worth their while. I think there's some opportunity in having, I like finding the next .xyz, and I mean, finding the next extension that truly can be, say, an open vessel, but good for really any sector of business, and maybe one sector will adopt it. But I like there's opportunity, I think, in having a domain name where you have some premium names, but you have renewals at less than $10. There's, and you make that part of your marketing strategy saying, hey, we have this dot, whatever. It's, you know, like I'm getting at, you'd want to market like a XYZ, meaning it's universal and it compete with .com. So you have the security you mentioned, but we need something. I mean, I think investors would like stuff to know. There's no chance of this having a renewal of more than $10 for the next 10 years. And if someone, there's going to be, one or two winners out of the thousand. I predict like a couple thousand coming out of this next round. But I like the idea. I don't like the idea, the expense. But okay, so I bring it all up because there's an interview on DNW with Ray King. He put together a website called earlywarning.report, and he's basically trying to let people that apply for names know if the extension they're applying for is going to be contentious, is going to have other applicants, and if so, what about your second choice? Is that also going to have potential competition? If it does, then your second choice is worthless. But anyway, listen to the DNW interview with Ray King. I'm 3/4 of the way through, and Ray put together this tool. He's the head of Pork Bun. I really like what he's done here, and it makes sense, But I know very few people are applying for a GTLD. You really need to have your money straight, and you really need to be a big company who has specific plans and understands the true responsibility of running a registry. There's a lot of existing registries, existing strings that those people got, bit off more than they can chew. And okay, so we're getting to our first case. ShirleyJones.com. I watched The Partridge Family. I'm old, so I know it. My sister, she was in love with David Cassidy. I mean, I think I love you. So David, let's talk about this case a little bit. The complainant was Shirley Jones. To me, she's famous. Yeah, I know Shirley Jones. You said anybody under 50 wouldn't know her. That's probably true. So talk about, I want to ask you, talk about when someone's famous and they haven't applied for a trademark for their name, how can they still establish that they have common law rights to their name if they haven't applied, for a registered mark?
Well, you need to be more than just a celebrity. You actually have to have a business because trademarks are for trade. And you have to sell some good or service underneath a name. So there's a Shirley Jones real estate in Florida. There are, I don't know, maybe thousands of Shirley Jones across the United States. And, they're sometimes they're using their own name and their own domain name, sometimes they're using another name. But just because it's your name, and you're famous or used to be famous, does not give you trademark rights. And they don't last forever. So you can abandon a trademark after 3 years. This is the default. If you stop using a trademark, someone else can go apply for it. And if you still have a registration, they can petition to have your trademark canceled if you haven't used it in the last 3 years. If you can't produce evidence, the USPTO will cancel it without any, um, hesitation. It's like no evidence of use. Okay, it's done. Bye. So yeah, Shirley Jones is really old. I had to look her up. I didn't recognize the name. She's like 94 years old. Yes, so she starred in the Partridge Family. When I saw her face, I recognized her, but I was just a little kid, so I don't remember that. I definitely don't remember actors' names. That's like, early 70s. No way. But yeah, so I'm very surprised that Richard Hill said that she had common law trademark rights. Now I know Richard is older than 50, but I think he jumped the gun on that. And you know, why does she need a name now? She's 94 years old. Does her does she want it for her state? Is her state administration asking for it?
It's
I don't
funny,
know. Maybe
David.
that's the reason for this complaint.
Why does she need it now? She's 94. What a bitch. It's a bitch to be old, huh? I mean, she does want it for her estate, I'm assuming. But uh, yeah, and I know Richard, and I was going to say, I'm sure. Well, first of all, she is in theater. She was in some Disney movies. I forget the movie she was in, like three or four before she was on the Partridge Family. I think she won an Academy Award for, But then I'm half-ass in the business, so and I'm always real familiar with the names. But yeah, she was in theater. Shirley Jones, well known. But you're right. I mean about the continuation. So she certainly, in my opinion, did have common law rights to it because she was known as Shirley Jones. She got paid as Shirley Jones. She would use her name on marquees to sell a play to be in a film. So you're right. You can't just be a celebrity, but if you use your name in say also in California, right? You have rights to your. There's different laws about your likeness and using your name, and there's basically additional laws that make it, I would say, easier to establish, yes, I have common law rights in my name, and so no one else can use my name or likeness and benefit from that. And they make it a lot easier than so if you are a celebrity, they sort of broaden the ways that you can defend yourself when somebody else is using your name, especially in advertising, because we see that all the time. Like they bring up somebody's name and they're like, I'm not endorsing that. And okay, so David's correct. You can't just be a celebrity and you're like, hey, that's my name. You have to, trade on your name and show that you trade on your name. But it's not extremely difficult if um, you know, if you're. Anyway, she was part of productions and she was a producer. But anyway, she like I had her name on marquees, and that's what brought people in to the theater. And she got paid via that name, and they marketed her name anyway. The point is, I believe she did have common law rights. The argument against it would be, what has she done? Is she got common law rights in the last 10 years? She hasn't done anything for the last 10 years. So, right, if you're not selling hamburgers at Hamburger Hamlet, you're no longer a fucking trademark owner. But the point is, she with her fame, you could see how Richard would say, okay, she had trademark rights, she still does, she's still Shirley Jones and so on. Okay, so the key here was the complaint was made against a person, Thomas Davidson, okay, out of New York. Why did he register the name? It looked to me, when I searched the registration, it looked like it was registered in 2021. So maybe I'm assuming that it dropped. Maybe it went to auction and then somebody picked it up in 2021 in September. But on the website, the guy was like, hey, well, he didn't respond to this, but he had it on there like, hey, almost like it was a fan site, but had links then down at the bottom that said mail order brides. I don't know, just some pay per clicks, and the complainant lawyer said, hey, that makes her that hurts her reputation and so on. But bottom line is because the person didn't answer, and Richard felt like, hey, number one, yes, she has trademark rights. Number two, the person's not putting this name to any good use, and that does mean something. And she did have trademark rights well before this 2021. So he just didn't really put this thing to a bona fide use, and went back and said, okay, was there bad faith and bad faith use? Well, the why the person would need to tell us, why did you register Shirley Jones? I mean, you're not Shirley Jones. Why did you register it? Just give us a good reason. And, so they made you answer. No answer for the respondent. The name was ordered, transferred. So she's 94. Jeez, David, can you believe that? That's her last thing she's going to remember. They came to her. She's on her deathbed. I like Shirley Jones. I shouldn't say that. She was married to Jack Cassidy, by the way. Yeah. So I know this business. So they go, guess what? We got the name. You got the name. ShirleyJones.com. You can rest peacefully now. Okay, we're going to have to check and see what she does with the site. But so you didn't like the transfer, David? This person getting their name. The respondent didn't respond, and he's not known as Shirley Jones. Well, what did he want the name for?
Well, it's a fan site. Like if you go to the website, you can see that it's a fan site. He's got pictures of her, which, I don't know. They're not really in the genre of being like a news site, but I don't know where he got them from. Maybe Wikipedia. But he does have information about her, so maybe it's like more like a Wikipedia page. And I think it's very thin. He does get about 25 to 50 visits a month just from the keywords on the website, mostly with her name. So it was a marginal site at best, but potentially there was an argument there for a fan site, which is a recognized doctrine under, LIPO overview, section 2.7. You could have a fan site, and that's legitimate non-commercial fair use. Even, newspapers have non-commercial fair use rights, even if they have ads on their site. I'm on the website. I don't see any spammy ads. There is a link in the header with a link to mail order brides. That's another page. It's not on the same page as the homepage. So I think that's the key thing there. There's no real PPC that I can see.
You're right. It's not at the bottom. It's right at the top. It does say we're a half-ass fan site. We like Shirley Jones, the inimitable, like unimitatable Shirley Jones, and they have a couple pictures. I'm looking at it, and then of course, but if they did do two things, didn't have, a mail order bride link and responded, then you say, I've loved the person forever. Here's when I picked up the name. I wanted to do it because I wanted to make sure that there was always something, to honor that person or to whatever. I mean, you just have to respond. When you have these, I got to say, these celebrity names, I know Jeff doesn't like them. Jeff's like, there's no reason, there's just no winning when you have some other celebrity's name. And if you're going to do it and you really want to say, hey, I own WrestleBrand.com and I want to call the guy out for all of his fucking bullshit. If you're somebody who wants to own a celebrity name or a politician's name, I think it's okay. You just need to, as they say in the UDRP business, you need to demonstrate a usage of it. You need to put into action how you're going to use it in a legal fashion. And in our country, we, always talk about free speech and the First Amendment, although, the rules aren't the same worldwide and domains are worldwide, that you have to, if you're going to get somebody a celebrity name, you need to show that I'm using this here's why I got it, here's how I'm using it in a legal fashion, and still you need some luck on your side because they'll transfer those away. But I always bring up Bruce Springsteen. I remember back in 2000 when he went after his own name and they said, no, this is just a fan site. And as I said, I mentioned Larry Fisher earlier. He owns AndyWarhol.com, I'm sure still. Yeah, I don't like to talk about it, but it's like, yeah, you're allowed to own, somebody else's website. And I always mention too, I remember when I filed a UDRP on behalf of Ice-T, and we won Ice-T for Ice-T. I mentioned he was on MC Ice-T at the time. This was back in 2000. But if anybody, Ice-T, several people would have rights to that. So that was a weird one. I could see, Bruce Springsteen winning Bruce Springsteen a lot faster than Ice-T winning that. But we won, Bruce lost. Okay, that's what you got to have people on your side.
So, the counter argument here is if Shirley Jones' estate or, her, she's not dead yet, so I would call it more of her estate administrator, um, had hired, say, Jeff to file an ACPA action in Eastern District of Virginia. The ACPA specifically allows people to sue over their names. And if the holder is in the United States, they're subject to a $100,000 fine, in addition to losing the name. So, that is probably the more appropriate way to go for these kind of names. And, you definitely don't want to be putting up Shirley Jones for sale. Buy it now for $100,000. That's definitely not going to work. But if you had it for $1,000, that means you're targeting the average Shirley Jones, not the Shirley Jones singer. And, that's probably more plausible. So who knows?
Yeah, and what you do is bring up that there's so many Shirley Jones out there. But David, you bring up a good point. This was a case where you're glad there was the UDRP if you're the domain owner, because they could have filed an ACPA action, which happened to me. Yao Ming did, and I could have lost not only the domain name but been penalized $100,000. This was back in 2001, and fortunately, I won the case and actually countersued and won $5,000. But the truth of the matter is, I wish I wouldn't have had to go through and have an attorney help me in a federal lawsuit, because you certainly need to answer then, because you don't answer and it's default against you. And boy, what a big fine. This ACPA, like I said, $100,000 penalty, possible an additional attorney fees too. But the point is, the UDRP is nice. As a domain owner, you're like, well, worst case usually is they just take the name, and then in a UDRP that is worst case. They an add-on, it's bad for your reputation, but they can still file an ACPA action if they thought, hey, we did contact this person, we did win the UDRP, but we realize this person is easy to track down and also has the money, and they did, in fact, when they had control of the name, did infringe on us, and we want to go after them now, and we want to go get this money. So it doesn't relieve you from a possible federal action, but usually they just want the name. But that's why, as domain investors, you really like the UDRP, because if it can get ugly, and maybe you have rights, but at least it's you're not having to go to federal court. So ShirleyJones.com, the actress, the celebrity, the entertainer, she filed this suit. Her lawyers did. They won. The name was transferred to Shirley Jones. She's got it. We'll see what happens. I'm going to check on that in a couple weeks and see if they're going to do anything with the site, make any updates. The second case that we're going to cover today is, I like it. It's Kirkland-Golf, KIRKLAND-GOLF.com. Okay, so a lot of us know Kirkland Signature is a Costco brand. People like it. People like Costco. People that like Costco love Costco. Like, it's a big friggin' deal. Okay, so you get a break because you bought fucking 128 pieces, rolls of toilet paper. And the quality's good. I got these undershirts. All right, whatever. To me, I was just like, it's not, fantastic. So, you like them. I guess they were better than Big Lots, but you didn't need to buy so much at Big Lots. Costco Wholesale Corporation was represented by David Kaplan of Kilpatrick, Townsend, and Stockton out here in California. The respondent, Muhammad Sufyan Afzal, out of Hungary. So I really like this case. Okay, there's a solo member panelist, Jeffrey Samuels. But I'll tell you a little bit about it, and then I'll throw it to you, David. So this guy registers Kirkland-Golf. Um, I believe he registered it in 2025. I'll have to find that. But anyway, he registered it for the sole reason of he has an affiliate website on Amazon. So it's an Amazon affiliate. He's got a store where he sells just Kirkland golf products. Kirkland is, Costco's brand. So you go to kirkland-golf.com, and I will say it does look at first glance to me like, so this is an official Kirkland site. I don't know, meaning it does look like their focus is Kirkland golf products, and I guess it's Kirkland signature. I wouldn't even have known, no difference to me. The person does put that it's a, Kirkland is a Costco company. Now, way down at the bottom, he puts, we're not related. It's a Costco trademark. We're not related to Costco, and so on. But throughout the website, he puts, quality. Kirkland is quality, known for quality, and Costco backs up this product, and so on. The thing is, so he built this website, and the links go to his Amazon affiliate site. Okay, so he's claiming this is fair use. I'm only going to be selling Kirkland golf products, which are real products. I'm not selling counterfeits. So I have a right to do this. And then the panelist, uses this Okie data test. So David, take it from there and tell us, how did this, we know it's Costco saying, hey, this guy's confusing people, but how did this guy set up his defense and tell us the decision?
Yeah, so his defense is fair use because he's actually evaluating different Kirkland golf products, including golf balls, putters, and so forth. And he's getting traffic to those specific pages. It's a business for him. He's getting 730 SEO visits per month. Ironically, I think Costco is upset because he gets 75 clicks a month just for Costco golf. And, another 70 for when will Kirkland golf balls be available? So people are actually searching for that. Kirkland wedge set, 32 searches, clicks a month. So that's pretty good according to SpyFu. So yeah, there was the OK data test, which is designed for authorized dealers, non-authorized dealers. But this was a different case. It's an affiliate site. And they used the Lost Mary case where you have the big disclaimer up there. There's a small disclaimer in the footer, and it's a really nice site. It makes it clear that the site is independent and nothing to do with Costco, and that he's an affiliate for Amazon. So he's fulfilling his FTC obligations and the Lost Mary case obligations there. So yeah, that was his defense. He's actually using it. It's a trusted brand, but he's actually using it well. He's not um, cornering the market. He's disclosing it. He's only selling trademark goods. So the links all go to the authentic Kirkland signature brand golf equipment. And that was the other thing. The trademark itself is only for Kirkland signature. Kirkland is a surname, as you're aware. Um, but they couldn't get a trademark for just Kirkland, so they got it for Kirkland signature, and that works. But so this domain name Kirkland-golf.com is just a confusingly similar variation of that, and that gave them standing. But there was fair use, and that's how it was saved. And anybody who's looking to do SEO sites and content sites, maybe it's the way to look at it. Like, we'll use this as an example. It's a dangerous game, but it worked in this case. So the panelists, everybody should take note of this, is Samuel. Let's see, what was his last name? Jeffrey Samuels. So I would definitely, keep him on your roster. If you get a complaint, name him for a 3-member panel.
Yeah, like you, he's got a name, the first name with an S on the end. Jeffrey Samuels, David Michaels. Hey, David, if when you go to the website Kirkland-Golf, and I think domain investors should take a look at this. It looks, yeah, I see Kirkland Golf. It has these menu: golf balls, golf clubs, irons, clubs, so on. Kirkland golf balls and clubs. So far, you're thinking it's got a little logo, Kirkland Golf, and you're thinking, well, this is Kirkland Golf. Okay, who are it is. It does make you think it's like I said, we don't know Kirkland's signature. Okay, and it's not about whether he has a trademark in Kirkland Golf, which I'm sure the guy doesn't. He's trying to use this in a fair use manner. But you go through the site and it looks like, yeah, this looks pretty official, meaning, yeah, so it must be all Kirkland stuff unless this guy's a scammer. So this is all real Kirkland stuff. I mean, like I said, he's saying it's real Kirkland stuff, and it is. And then he goes through premium quality at affordable price, uses a lot of the terms they probably use, trusted brand, performance tested, perfect. He's got all these things, and then he talks about the best sellers. So you go through the site and you're just thinking, so this must be, I would think they're like an authorized seller. That's what it would look like to me. They're an authorized seller if they're not part of Kirkland Golf themselves, because I'm thinking could be Costco set up a site. I mean, the owners of Kirkland Golf Products, Kirkland Signature Golf Products, and maybe set up a site. It looks pretty good. It'd probably be a little more, a little more impressive, a little more extravagant, or if Costco is involved. But anyway, it's only down at the bottom, and then down at the very bottom, that confuses people. When you see a copyright 2026 Kirkland Golf, you're thinking the average person doesn't know what the fuck is a copyright. Is that a registered trademark? All I see is a letter with a circle around it. That means something to me. Is that a C or an R? I don't know what the fuck. Okay, so you see that and you think, can they do that? So that's official. And you're just saying all the bullshit on my
So,
website and the art and everything he's saying is his. He owns the copyright to all that, and he does. Okay, then only it's very bottom right. Kirkland is a trademark of Costco Wholesale Corporation. This website is not affiliated with, endorsed by, or sponsored by Costco. Product names, logos, and brands are the property of their respective owners. Well, the importance of this whole case is this is one of the first ones, I guess the initial one, that has shown having an affiliate site, an Amazon affiliate, can be considered fair use of a well-known mark. Now, David, you said without signature, Kirkland isn't well-known or can be. But anyway, they're used, I like this whole idea of I've never seen an affiliate site that I liked as much as this one. So I like that this guy registered a domain name, had his Amazon affiliate set up. You just used really this as a landing page. I'm going to click on golf gloves and I see, okay, so he has another page of golf clubs and then he explains it. Looking for golf clubs at the combined, and he talks about Kirkland. He left top pick Kirkland. Okay, and then each it says visit store, check price. I'm sure when you check the price, it takes him to the Amazon affiliate. Well, I love these kind of things. If anybody was setting up an affiliate site, this is how I would do it. Just go set up your affiliate, whether it's Amazon or wherever. But then you use the domain name with some landing pages, and then just links right over there. And then if you get your ass in a sling, they come after you with a UDRP. This is the type of case that you're going to want to refer to. It sounds to me like it's the only one so far that is a winner for an affiliate program that claims fair use. Okay, was that right there, David? Did
yeah, it's
they say
also,
this was the first one?
yeah. So the other part is you mentioned the copyright in the footer, Kirkland Golf. So when you put copyright in the business name like that, you have to have a trade name registration or a corporate name registration. I couldn't see trade name registrations on open corporates, but there was a Kirkland Golf LLC in Oregon that's been closed, but that was actually registered in 2006. There's a Kirkland Lake Golf Club near me. So anyway, yeah, you have to put either your personal name there or your business name that you've registered there. You can't just make your website name to be your copyright owner, because that's not really effective. It's like a pseudonym, but you have to register it someplace because you're using it as a business.
Yeah, I can tell you, Costco and other brands, they don't like this because it can open the floodgates. And Costco probably, like you said, David, saw that, hey, somebody brought to our attention. People are searching for golf products. They're they're actually coming across this website. It may be minimal to them to start, but then they realize, we need to stop some of these sites before it becomes widespread, and there's a lot of people that are selling our stuff in these affiliate sites, and it shouldn't be allowed. And then they get a ruling that says it is allowed. Now, Costco's the kind that may pursue, a lawsuit to try to stop this, because it could certainly get out of hand. Not that they could necessarily win the lawsuit, it'd be a lot of the same defenses, but boy, it could really cost you. And this guy could put you out of business. That's what these federal lawsuits, or just any lawsuits, do. Put you right out of business if you're not a big company. If you're a big company, it's still terrible. Costs you a lot of money, and it hurts. But yeah, I would say if you're going to set up an affiliate site, it's a good template, because if you need to defend yourself, you can, well, use some of these same defenses. And it's not that it's necessarily going to work. You need a panelist that also feels the same way. All I got to say is I know some panelists and some brand attorneys that they don't like this at all. They don't like it. It's confusing. So what I would think too is set a banner at the top. I don't think it's going to hurt you too much to say we sell, of course it's always fun to say we sell, authentic Kirkland golf product, but however, we are not associated or affiliated or, endorsed by the mark owner or the manufacturer, directly. So, because I just think they got away with murder. The bottom line was they used the Okidata defense, and in the past, there was whatever these four prongs to the defense, that one of them was you need to be very, very clear in your disclaimers on the website. This case, the disclaimer was not very prominent, was only in one place, but yet the panelists felt that because they met the other criteria, meaning not selling counterfeits and only selling this one brand, that they did meet the criteria. And so this being such a weak disclaimer, they looked at the overall picture. They didn't, in the past, sometimes because this disclaimer wasn't very prominent, that could have cost them the case. But okay, so interesting. So, a lot of domain of it. This is something that's really related to domain investing, or, when people say build out a site, it's something that all of us can do. And reselling products, that's how you make some money, if you know what you're doing. All right, our final case for today, agena.com. Agena, I guess. So this case, let me see here. There was something I was looking at with this baby. Yeah, anyway, so this case, the complainant was Centaurus Group out of France, and they are the parent company to several companies that have Agena in it. Agena 3000 Data Management, Agena 3000 ERP, but they have these companies, Agena 3000, with different names included with it, but not just Agena by itself. Okay, so that's important to know that so this guy, Philip Sazovsky, okay, out of the Czech Republic, he bought this name back in 2000, I believe. Was it 2000? And this company basically just was pissed and wanted it. They said, since he's not doing anything with it, and he's got it on Brand Bucket offering wanting to get $81,000 for it. It's way above what he spent. He has passively held it. He's never legitimately used it. To know someone bought a word that's not, it's not really a word. Why did he buy it? And so on. Let's see.
It is a word.
Go ahead. It is.
It is, and here's the deal. The complainant's name is Centaurus Group, Agena, Agena 3000 Data Management, Agena 3000 ERP. So if you read this page and you scroll through, you find the word star, and Beta Centauri, the second bright star in the Centaurus constellation, is called agena. That's a common generic term for this. This name has been around for centuries. There is I think 2 or 3 places in the world with the name agena. There are 469 companies, according to Open Corporate's name agena, that are either still active or were active. And yeah, it's common throughout the world. It's very common, popular in Europe. And so it's not just the complainant. So the complainant's on Agena 3000. There is Agena Bio in San Diego, right off the, I think it's off the I-15. So yeah, there are other higher value users of this particular name. And the fact it's priced at 81,000, I think is fine. So yeah, the complaint was shredded because the trademark is just a design mark. The word agenda by itself is not distinctive because it has a common generic term. Like it's a generic term, right? So by definition, it has an established meaning. So it's arbitrary in respect to whatever the service is offering. So that's makes it registerable. But they didn't register like that. They registered the design mark with it and with just the letters in a special form. And that was in France. So they don't actually have a strong trademark. And yeah, there's so many other companies out there that use it. And I think that was the real defense. So I think in this particular case, it was morally unethical to file this complaint because why should this French company think that they have greater rights than the domain owner who registered the name in 2000 or 1999? And they only opened up their first business in 1999. And they're just one of many. So I think this is one of those cases where some people would argue that it was attempted theft. What do you think?
Yep. I know Nick Gardner, the panelist, said he did rule RDNH. So he said, complaint denied. You guys abused the system. This was registered in August 2000. You should have known. And you're right. They're even saying, David, that it's a Jenna is a girl's name. But there's numerous companies that use a Jenna in their company name. And there's several companies that have, trademark rights in this name with other words. But basically, the complainant was just saying it's been passive holding for 25 years, and them wanting to offer it for sale for that price. By the way, now it's 150,000, so it looks like they raised it 70,000. But just a flimsy complaint. But the company, I guess, was hoping there was not going to be an answer, and you don't know what panelist is going to get a hold of it. And when there's no answer, and a panelist could be somebody who's real familiar with this company in France, anything goes. So they spent, $1,300 or $1,500, I think, if it at the forum. Let me look. I think it was a
Well, no, they
WIPO
spent more
case.
than that.
Yeah.
So how much would Jeff charge for preparing and filing a UDRP complaint or a typical UDRP lawyer? What do they normally charge? 5,000 plus disbursements? What is the
Well,
going rate?
yeah. I mean, if somebody's got all their stuff straight and a strong case, go a little less than that. I mean, if they really are organized, and then so I could say a little bit less than that because I know, but it's case by case. If someone, there's, sometimes there's more work to do in certain cases. Sometimes people are really organized and provide a lot of evidence that we know we're going to feast on, that we're going to use and then of course looking at the complaint. So usually when someone comes to hire a law firm, they're going to say, here's the complaint I received. We're going to look at the complaint, and then we're going to make the decision whether or not we're going to take the case, and then what the fee is going to be for the case. But yeah, minimum you can figure 2,500 to $3,000 up to 10,000 for a UDRP, and that's with not just Jeff but any lawyers in the space. Okay, and every once in a while, if you really appeal to someone, you got your stuff organized and you really appeal, you might be able to find somebody in the space who will even do it for less. But all domain name lawyers, I know the smart ones always say, hey, are you willing to spend an extra couple grand for a 3-member panel? Because we always like to have that even in, say, airtight cases. So like in this case, if it would have been a single member panelist who, um, single member panelist who was really brand favorable, things could have went in another direction. I don't think so for this Agena case, but always. So basically, when you're hiring an attorney, you're going to be spending minimal, a few grand, plus they're usually going to recommend you get a 3-member panel, which is going to be another couple thousand. So always 5,000 is a reasonable amount to think you're going to need when you hire a pro. And we know a lot of domain names, you're just trying to sell them for $49.95. You might have the price at $29.95, but yet you get a UDRP on it. So to spend that, it just doesn't make sense at all. I mean, it does not at all. And even for a $10,000 name, you're going to spend $5,000 to defend it. Now, they try to hold it against you when you lose a domain dispute, which I really don't like at all, because sometimes it's just a bad decision. And then they try to say, look, this person, especially if you're a domain investor, look, they buy names. They have a portfolio of names, and they've lost names before through this process, through this, using the UDRP. And it's just an indication that they, are that type of investor, or they don't care, or they simply will cyber squat, even if it's not all their portfolio. Some of their portfolio, they simply do that. So, but domain investors get the worst end of it always, meaning they'll try to hold that against you. But yet we know some lawyers file many cases that they lose, many that they'll end up getting an RD&H on, but yet it doesn't seem to follow them around. Now, I can't say that, always, because there are a couple, we know of several companies that have attorneys that they lose these UDRPs, they get RD&H, but I haven't seen a respondent add in there. Maybe John Berryhill has done in his response saying, hey, this is the same attorneys that lost these cases and so on. Usually I don't see often that the responses bring up, instances of RD&H against lawyers. So I'm sure it's got to have happened, but so anyway, these 3 cases today. Shirley Jones, she got the name. That was a transfer. And then Kirkland-Golf, the domain owner won. He said, fair use. I'm selling Kirkland products through an affiliate program, and they're legitimate products. I mean, they're real, authentic Kirkland, and I'm not selling any other products. I'm not confusing people that I'm Costco or Kirkland brand. So I have rights to this, and the panelist, Jeffrey Samuels, agreed. So the domain owner got to retain Kirkland-golf.com. In this last case, just a great domain name, AGENA. Guy registered it back in 2000, had it for 25 years, and finally the company, they want a certain name. They didn't want to pay 80 grand. They thought, I just would like to be in the room when someone says, let's do it. I know for a fact many times they say, let's file it. Well, yeah, but what's that going to cost us? And then someone goes $1,500, and they go, that's it? And they go, well, what can happen? Well, what can happen if we lose? Not a damn thing. And the lawyers, most of them don't even know there can be a reverse domain name hijacking. If I was a lawyer and someone told me that, I'd say, quit tickling me. Who cares? Reverse domain name hijacking. I hope I see that panelist in Costco. Anyway, it just means nothing, RD&H. Okay, so that's going to do it for today.
False statements in their complaints, those attorneys can be disciplined and disbarred. Just look at John Eastman. He got disbarred, but a lot of attorneys get disbarred for making false statements in court complaints. So,
people need to put their foot down. I know you've always said that, David, about file a complaint against them. File a complaint to the bar, to the state bar where they're located. Don't let up. In at least with these, you have, look, they filed. It doesn't have to be a legal dispute that you had with that attorney. Meaning, it doesn't have to be a lawsuit that you felt they did something wrong on, or a relationship with you specifically. It can be, they're held to a higher standard, lawyers are, when it comes to participating in even these administrative type hearings like a UDRP, but need to go to that next step. All the lawyers, as much as they'll say bad things about each other, they all pretty much stick together, meaning no one, don't complain about me. I'm not going to complain about you. I might not like you, but no one likes to go to those higher authorities, basically to their bar in their state and make complaints. But probably needs to happen. I think when there's a UDRP, I'm sorry, RDNH ruled, it'd be nice if, geez, could you imagine if WIPO or the forum stepped in on behalf of their panelist and said, we'll file, a complaint with a state bar of that law firm because that's the least we can do. They'd never do that, not in a million years. But that'd probably be a way to handle it. But bring that up sometime. They would never do that. All right. Well, we're going to be here next Tuesday. That's noon Pacific, 3 p.m. Eastern. We'll get back on our horse here and talk about some lawsuits. We're going to talk about some, of course, some more recent UDRP decisions. So please join us next Tuesday. This Thursday, boy, I'm going to tell Josh, he already knows it, that I'm not going to be able to make this Thursday's DNX show because I'm going to be at the Dominion Conference. Josh, I believe, is still going to put on a show. So I know he could use some support. It's an open discussion. Have some friends there to join him on stage so he doesn't go on by himself. But so that's this Thursday, DNX show. We always do that for domain investors, 10 a.m. Pacific, 1 p.m. Eastern. But until next Tuesday, hope everybody enjoys the rest of your week and the upcoming weekend. But thanks for being here and take care of yourself. See you next week.